legal advice and legal representation for people for over 20 years now. It's been actually 25 years. Doesn't seem that long, but a lot has changed, thank you, in 25 years. We have gone from a very simple process to a process that's getting more and more regulated and has more and more requirements for employers. And a lot of people see that and think, well, you know, it's not like the good old days. But actually, there's been changes that make the H2B program more reliable and probably better than it's ever been, or at least in many years. And as long as people are doing things the way they're supposed to do them, it's a great program, and it's a solution to a huge problem nowadays, which is labor. A lot of people, we're in a labor crisis since COVID. A lot of people have commented to me that they just literally cannot get U.S. workers to take jobs, and so they are either turning down contracts or losing contracts and really making business very difficult because they can't get people to stay on the job. Even if they can hire them, they won't stay. And so now we have, with these supplemental visas for Northern Triangle countries and other countries that they've added, and we'll go into all that, we have a dependable program. And you can actually know that you'll have labor next year to go ahead and take contracts. When people were subject to the lottery and didn't even know if they were going to get workers because they could have been capped out, it was a totally unreliable program. You still couldn't sign the contracts because you didn't know if you'd be capped out by the lottery. But now with the supplemental visas, there are visas available the whole year. There have been the last 3 years, and even though it might not be the particular workers that you want to bring, we can get you very dependable workers, hardworking workers, and for landscaping or construction, they can be trained just like any workers have been trained before, and they can be a reliable workforce. So we'll go into all those. We'll go into some strategies that our clients are using very successfully. We'll have some testimonials about that. We have added additional processors this last year, and so we'll be introducing our processors as well. And I think we've got a fantastic program. And one thing about this seminar is we train you basically everything you need to know about the employer's responsibilities in using the H2B visa program. One of the downsides of regulation is there's more enforcement. We had this last year, both DOL and USCIS got more federal money for enforcement because they said a lot of employers weren't abiding by the terms of the program and everything, and they did find out that many weren't. And so they're going back for more money. And so a lot of people look at that as a negative, and in some sense it is, but as long as you're doing everything according to the requirements of the program, you've got nothing to worry about. I was talking to one of my clients here this morning that said they went through an audit, and they didn't really find anything wrong. They had a few suggestions, but that they were doing everything right. And that's how everybody here, if you do get audited or an investigation or whatever to monitor your compliance, you can come out just perfectly with, you know, nothing wrong. So we're going to go ahead and get started. And I want to thank you again for being here, taking the time out for coming. And we love seeing our old clients, and we also love meeting our new clients. And so welcome. Just FYI, before I get going, if you need to use the men's or the women's restrooms, they're out of the door to the left. There's coffee in the back, and we'll break right at noon for lunch. We have a hacienda fajita lunch coming, so we'll break for that. And if you would, introduce yourselves. If you're a new client, you know, please greet us. We want to say hi to you while you're here. All of our legal assistants will be here as well. There's 8 of us in the office, and so be sure to greet your legal assistant as well and introduce yourself. If you'll turn to page 1 in your handbook, we're just going to be following the outline in the front of the handbook, and there are exhibits in the back that are there's a lot of new exhibits in there, and we even have a few, if you didn't get the insert, we have a few additional exhibits that we added at the last moment after the handbook went to print. And so if you didn't get that, be sure to get that insert. The H2B program is not for everybody. There are 4 different types of H2B temporariness requirements, and an employer has to fit into one of those 4 types of H2B temporariness standards, and if they don't, they can't qualify for H2B visas. There are other requirements as well that an employer has to live up to before they can qualify for H2B visas. We'll go over some of those up front. So whether you can use the H2B program successfully or not, you first have to ask yourself, do you qualify for one of those 4 types of temporariness? We really only represent clients in 2. I've done 3 of them. There's one that's very rare. Actually, 2 of them are very rare. The first one is seasonal. And seasonal means that you have a busy season, but then you close down for a certain part of the year. So if you have no employees, either permanent or temporary, for even 1 month, but normally 2 or 3 months, if you shut down, then you're a seasonal H2B business, not a peak load. And so an example of a seasonal H2B business would be ski lodges. A lot of ski lodges use H2B visas. They are only open for about 6 months out of the year, and so they need that seasonal labor to come in when they're open and then go back home when they don't need them. And landscape companies up north, a lot of them will shut down during the winter months because there's snow on the ground, they're not doing any landscaping, and they take it as a vacation time because they really can't do that much. There's also intermittent. Intermittent is something that is unpredictable when you'll need the workers. Roofers that do hurricane repair, that's all they do. They sit around, wait for a bad storm somewhere, and then they go there and they advertise and they fix a bunch of the roofs. Maybe there was a tornado that went through, or there was a hurricane that went through. Those are intermittent, and they can apply right when it happens, and they can take their workers they got, but they're going to need more. And during the time that they'll be repairing, they can get H2B workers, that temporary need. They're not going to be doing fixing the roofs except for the period of time that's necessary after the hurricane or tornado. Then there's a one-time need. A one-time need is something that the employer has never done before and will never do again. And I've done one-time need. And when they say one-time need, they mean one time. The employer that did the one-time need with me, and we did get him as workers, we brought him from India, and he needed, it was a big nursing home chain. They needed certified nursing assistants, and so we brought him over from India, and they liked him so much that they told me they wanted to do it again. And I said, you can't do it again, it's a one-time need. And they said, we want to try. And I said, you won't get it. And they said, we'll pay you to try for us. And so we tried, and of course they were turned down. So it's just a one-time need, a good example of a one-time need. And this could be something that would work for landscaping employers or construction employers, demolition employers. But the example I use is, let's say you're a home builder, and all you do is build homes, but you are a member of a church and they're building a church, and you've never built a church before, but you could build this church, and they need a stained glass expert to come over from Europe and do their stained glass. You've never done that before, you're never going to do it again, it's just something you're doing for your church, and you just build homes, but you want to bring the stained glass expert over to do the stained glass on the church building. That would qualify for a one-time need. And so something you've never done before, you'll never do again. Possibly you could get a real serious hurricane or something that destroyed a bunch of homes. Let's say we had this happen not too long ago in Houston. They had some real bad storms, real bad flooding. There were whole areas where homes had to just be demolished, or they were already partly demolished and cleared out so they could rebuild in certain areas that were adversely affected. And so they're going in a lot of times from other areas of the state to take that business. It's only going to last for, 6 or 9 months, maybe a year, they possibly could say, we've never done this before, but there's a lot of business there and we're getting people calling us, and they could go and do that. But most of our clients do what's called a peak load need, and that's number D. And a peak load need is a business that's a year-round business that has a peak season. And so the temporariness is for those months that are their peak season. I used to do all different types of H2B applications. I would do nurses, I would do resorts, I do cooks. We brought them from all over the world. And a lot of those kind of unique types of applications are a little difficult and time consuming. And I began realizing that my landscape and construction clients were a lot easier because I wasn't getting as much argument from the Department of Labor in those applications, because they know their peak load, they know, or some of them are seasonal, but they know that people aren't mowing lawns when the grass isn't growing during the winter months. And because of that, landscaping is the #1 user of H2B visas. And I decided years back, why am I making life complicated for myself? I'm just going to do landscapers and target that business, construction and landscapers. And so that we can do the other types, and we do, but we don't target those other types of business. We target primarily landscape employers and construction. And they are usually peak load. They're usually busier for the spring, summer, and fall, but then they'll slow down during the winter months. I'm going to go into also how employers can avoid the cap altogether permanently if they'll make some major changes in their business, or they might not be terribly major, but they would have to be doing some things during winter months. We have about 20 of our 360 plus employers' applications that we do every year for about 5,000 workers. We have about 20 of them that do winter apps. And if you do winter applications, you can keep the workers in the country for up to 3 years and never be subject to the cap during those 3 years. And if you stagger the workers out, 1/3 of the workers go out every year and stay out for 3 months, you can do that indefinitely. You can do that for 30 years and never be subject to the cap. And so what we are encouraging a lot of our employers to do is to develop maybe holiday lighting, winter business. Northern states can start offering snow removal, to do that during the winter months. And it doesn't have to be exclusively those things. You can even add other winter duties in there, but something that's exclusively winter will allow that application to be a winter-only application. You start another company with a different EIN number, and that's not totally necessary. We just don't want them coming back and trying to make the argument that you're a year-round need so that you don't qualify for that peak load. We want each business to be a peak load business, one for winter and one for spring, summer, and fall. And if we can get the employer doing that, doing it properly, where it's a legitimate need, employers can keep the workers in the country year-round, stagger them out at 1/3, going out 3 months each year, and never be subject to the cap again. And so our number of winter apps is increasing every year because of that. Another thing you have to ask yourself in determining whether H2B is right for you is, are there sufficient qualified U.S. workers? That's really a no-brainer in this labor market because we're in a labor crisis. And I have not talked to one landscape employer that says that they have all the labor they need. Everybody tells me they cannot hire sufficient workers, and if they can hire them, they won't stay on the job. And so, but if the Department of Labor tests that and asks you to advertise for U.S. workers through the state workforce agency, and you get all the hires you can possibly need, then you don't qualify for H2B. During the recruitment that's required, most of our clients are getting no applicants. Some are getting some that aren't interested and didn't actually apply for the job, but the state workforce agencies just send them out. But very few people are getting any hires. I don't remember anybody the last couple of years that has gotten more than 1 or 2. And I'd say 90% of my clients are getting no hires at all. No applicants that are actually interested in the job or will even show up. And we'll go in just a little bit in the presentation explain how to do that recruitment to where you only get people that are actually interested in the jobs. Then you have to ask yourself, will the hiring of foreign workers adversely affect the wages and working conditions of similarly situated U.S. workers? So what they don't want, and you'll hear people say this a lot, people will say, oh, these H2B employers are just trying to bring in cheap labor. I don't know of any H2B employers that are getting cheap labor because they're paying more with the prevailing wage, but they're paying that to have dependable labor, and a lot of times that's more of a benefit than paying cheaper prices to have people that will come in and actually work and stay on the job. But it has to not adversely affect the wages and working conditions of U.S. workers, so they don't want it depressing the wages. And H2B employers are actually, like I said, usually paying more than their competitors are a little bit. And, but it has to be that they're not depressing the wages and working conditions of U.S. workers. Some of the costs and benefits of using the H2B program, I see the glass as being half full, not half empty. You know, it's still, H2B is really the only viable option right now for labor. The U.S. labor market, for the most part, is not interested in these jobs. They're not interested in labor-intensive, hard work, and they're not interested in seasonal or temporary peak load work. They want year-round work, and so usually they're not planning on staying on the job. They're not going to make a career out of it, and so this provides labor when nothing else will. Some of the benefits are you get workers who actually want to work. We are now bringing a lot of workers from Central America. These workers have not been, spoiled a little bit. I love Mexico. I lived down there myself a couple of years, and we've been bringing workers up from Mexico since I started. But a lot of the workers from Mexico have gotten a little Americanized. They have a little bit more as far as demands and things like that. These workers coming up from Central America that have never been here, it's like it was in Mexico years back. And Mexico is still this way as well. But the wages in Mexico or Central America are about $50 to $75 for labor a week. And they can't support their families on that. And these guys are coming up, making $16, $17, $18 an hour, and they're pinching themselves on the bus or on the plane, thinking they're dreaming, that they're going to be making that much money and working legally in the United States. And so they come up and they're very appreciative of having the jobs. And the biggest complaint that we get out of H2B workers is they want more overtime. And so these guys come up to earn money, they want to work, and they're sending as much money home as they can. And a lot of times U.S. workers are just looking at it as a temporary position. These are workers who will stay on the job for the entire busy season. You won't have that HR nightmare of hiring and training and then staffing your workforce just to have them leave 2 or 3 weeks later after you've invested all that time and effort into hiring and training them. You have workers who normally will work harder than U.S. workers, and I hate to say that. I'm patriotic. I want America to be the best at everything, but it's just gotten to where there's certain jobs that U.S. workers are not interested in anymore. If you try to get U.S. workers to pick crops and do agricultural work, it's very hard to get U.S. workers to do that work. That's why we depend on a migrant workforce to come up and do our agricultural work. But it's getting that way with a lot of these seasonal jobs or peak load jobs as well. And you have workers that can only work for you. I have a lot of employers ask me, well, why don't I try to get permanent worker visas for these H2B workers? There's a lot of downsides to that. If they apply for a permanent visa, they will not qualify for H2B anymore, and they can also work for anybody. So they can go take a higher paying job. And so the minute they get a green card, is what it's called, or a permanent resident visa, they can work for any employer. An H-2B visa, as many of you know, the name of your company is on their visa. They can only legally work for your company, and you can bring those same workers back year after year. So that's a real advantage, because if you're going to put the time in to train them, you want those workers coming back year after year. I have employers now that have been using the program for 5 years when I represented them, and now they've been using the program for like 30 years. And they're bringing the same workers that they were bringing up back then, or many of them are the same workers that have been working for them for like 30 years. When the workers get here, they just go to work. They don't need any training. They know exactly what they're doing. They know all the procedures and the drill, and they go load their trucks up and go work the jobs. And so they can only legally work for you, and many times those workers are experienced because they've been coming back year after year. Also the costs, the prevailing wage is a little bit higher usually, than the local wage. It's not much, but it might be $1 an hour or something like that higher. But when you factor in the cost of the HR nightmare of hiring and losing and training and not being able to staff your workforce, it's actually less expensive, because you've got a workforce that you can depend on, and they're a hard-working workforce. The application costs, you do pay our cost, which is pretty competitive. You're paying for the USCIS fees, which went up this last year, and we'll go over that in a little bit. You're paying for the corresponding employment fees for similarly situated workers in your company would have to make the same wage. Those things do drive the cost up a little bit, but when you have a dependable workforce and you have all the labor you need, those costs are offset in many ways. Just one way that the costs are offset tremendously is overtime. When you're short-staffed and you can't get enough labor, and I talk to people all the time that overtime, I don't want to say it's killing them, but it's killing their profit margins. It's really difficult to have to pay 15, 20 hours a week in overtime. It takes a lot of the profit out of the jobs. So you can, when you have enough labor, and you can even increase the labor to meet your needs, you can keep them at about 40 hours a week. They want to have overtime, and you'll still probably work some overtime, but you won't be working as much overtime. That alone can offset the costs of bringing the H-2B workers. How to offset the cost: make sure you hire more H-2B so that you can keep them at about 40 hours a week. A lot of our clients have decided to go to 4-day weeks, because they're usually working 10 hours a day anyway, but they keep them at 40 hours by doing 10-hour days, 4 days a week, and they'll have two different groups, some that are working Tuesday through Friday, some that are working Monday through Thursday, and they'll have those crews on different days to where they're keeping them to 4 days and getting their 40 hours in that way. And it saves on the overtime, because normally, even if you're working 5 days a week, you're starting early still, they're getting back later, so you end up paying overtime. And by going to a 4-day week, you can offset even more of the overtime. There are application costs. Those cannot be passed on to the worker. It used to be legal. People used to do it. It's no longer legal, and it can end up getting civil money penalties if there's an audit. Our costs and the costs of bringing them, the transportation, things like that, cannot be passed on to the worker. But when you spread that over 9 months, it's really affordable. I ask a lot of clients, when I'll add up the cost to them, it usually comes out to about, on average, about $1,500 per worker. All the costs involved in it, about $1,500 per worker. And I'll ask the employer, if I could get you all the labor you need, but you had to pay a sign-on bonus to keep them here for a full 9 months of $1,500, would you do that? And I've never had anybody tell me no, because of the advantage of having those people on the job working for 9 months is worth the cost of bringing them. And so there are some things that are not included in our fees. I'll get to those in a minute. The costs are more than compensated by eliminating the HR costs of hiring, training, and losing. Eliminates that HR nightmare and allows you to grow your business. And this is a huge deal right now. through H2B, you can know you're going to get labor to work your contracts next year. Right now, the business and the contracts are chasing the labor. So if you have labor, you can go out and get business, because a lot of people that don't have sufficient labor, I hear this all the time, they're losing contracts because they don't have the labor to work the contracts. And so the customer is saying, look, if you can't service our contract the way you're supposed to, we're going to find somebody else. And so there's a lot of labor problems, and so a lot of these contracts are looking for people that can service those contracts properly. To service them properly, they have to have labor. And not only can you meet your contractual obligations, but there's a lot of business out there that you can take and even grow your business if you have sufficient labor to work those new contracts. And so that's a big advantage, to be able to grow your business even in a poor economy, or even in a labor market that is in crisis. You can grow your business when other people can't, if you have the labor. So when should you apply? We recommend applying, and by the way, they're incrementally starting another step in the process called registration. It's in the regulations, and they're implementing that piecemeal. Right now they have the registration number that they're putting on approved labor certifications, and that allows you to be grandfathered in for the next 2 years. They're not going to question your seasonality or the number of workers if you've been labor certed. They'll give you a registration number, but the regulations have a whole nother process 150 days out that is the registration process, where you're proving your dates of need and number of workers. So it's going to push the process out another couple of months, to where we're literally starting in the summer for the next year. And so it's basically going to be going through the process, starting in the summer, and then getting the workers in, March, April, May, and then basically about June, starting the process over again. We recommend that even now. We start early. We try to make it to where you're not stressed, we're not stressed. We have plenty of time to get all your additional supporting documents and everything signed and reviewed, and make sure that we can advise you properly and have a client consultation, and we have time to do all that. So it's best to start about 12 months out, get all those documents done, the payroll summaries, the sales summaries, which they still ask for. They're not required to be sent in, and they're only asking for them in probably about 10 to 20% of the cases, so we don't send them in on any of them. But if they ask for them, we want to have them ready, so it gives us time to do those. And we can get you set up. We can explain what you have to do if you're new, and the process, and then we need the supporting documents. Those support the dates of need, the number of workers, peak load months for that position, and allow us to build a good solid case for you. Registration, as I mentioned, will begin 120 to 150 days out. I would expect them to start that next year, or in the next couple of years at least. It's already in the regulations, it just hasn't been rolled out yet. And H2B application starts about 75 to 90 days out. We will always file your application at 90 days out. The filing window for an April 1st start date is January 1st through 3rd. We have to have your application totally ready to go by then. So from this seminar until we file in January, we're putting your whole application together, making sure everything looks good, and you're ready to apply and be successful. And then the H2A applications, if you're an H2A employer, those begin 75 days out. I will spend some time toward the end of the presentation to talk about H2A. There's a lot of employers that could be using H2As that aren't. If you have a nursery, if you have some greenhouses, even if you have a ranch, we do a lot of ranches, and those workers can free up your U.S. workers to do some of the landscaping duties when your H2A workers come in, and so they can still free up some labor that you have. Maybe you have a grass farm, you have a tree farm, something like that. You can know you're going to get your workers with H2A. There's no cap on the number of workers. We've never been turned down on an H2A application. I won't take one, that we would be turned down on, but it's a real good way to also manage your labor force, to where some of those U.S. workers that are working on the grass farm or the tree farm or the nursery can be moved over to landscaping during the busy season, and those H2A workers can handle the nursery or the tree farm. And we'll go over that in just a little bit as far as using H2A workers. Alrighty. And we get contracts showing seasonal need. We get the contract summary, payroll summaries, letters of intent. A lot of these things are still very important. A lot of people don't like doing the letters of intent, but Department of Labor and USCIS still love those letters of intent. Those help. We try to get those from you, and we try to go over all that with you and make sure everything is supporting your application in a consultation. All right. One thing we're going to go into is how many applications to file. And I'm going to give one of our clients is going to give a testimony here right before lunch. They have several offices in several states. I think last year they did 15 applications. I think they're doing 17 this year. But they use all of our recommendations of doing both double apps and duplicate apps. And if you follow this strategy, it's as guaranteed as anything can be that you will get your labor, and even if you're in the lottery, you can do duplicate apps that are not in the lottery and bypass the lottery as a backup app of what we call an insurance app. And so a lot of people, when they're just doing one application and it's subject to the lottery, they only have about a 33% chance of getting that application in Group A or B, to where they're going to be able to bring maybe some workers that they want from Mexico or something like that. If they're a little bit more flexible, they can bring workers from anywhere and know they're going to get them. And I'll show you real quick on this, and we'll go over this a little bit more in just a little bit. The best strategy that people can do right now is either a 2-app strategy, a 3-app strategy, or a 4-app strategy. And we give discounts on those other strategies, which I'll go over in a little bit. But if you are shooting for a 4/1 start date, that most people are, and we have others that are shooting for a March 20th start date for those Northern Triangle applications, we can divide that up into 4 applications. And if somebody does 4 applications, they're going to get all the workers they need, and should be, barring no consular delays or anything like that, should be able to get all the workers they need for the dates they need. So we will do usually a double app strategy for the 4/1 start dates. And the reason we do a double app strategy is because it gives you 2 shots at the lottery instead of 1. And so if you buy, if you buy 1,000 lottery tickets, you got a better chance of winning the Mega Million than if you just buy 1. Well, this isn't Mega Million, and the odds are not 300,000 or whatever it is for winning that. If you're doing 2 apps, our odds this year, if you did 2 apps, one for entry level and one for qualified, our clients had a 75% chance of getting one of their apps in Group A through C if they did double apps. So that's double. And then over here we do a duplicate app, and I'll explain the difference. We do a duplicate. So the 4/1 apps are subject to the lottery, right? And so you're going to go into a computerized, randomized lottery that puts you in Groups A through G. And if you just do 1 app, you got about a 33% chance of getting that 1 app in Group A through C. But if you do 2 apps, we had a 75% exactly. We looked at how many did double apps, and how many of those got one of them in groups A through C, and it was exactly 75%. So what we do, let's say you're getting 21 workers, and so you're getting 21 workers, and so maybe on entry level you're doing 11 entry. We divide that up into entry level, which is no experience, and then you're doing 10 what's called qualified. Qualified have 3 months experience. And if you do 2 applications like that, we had several of our clients get both applications in A through C, but we had 75% of our clients get one of those applications in A through C. We give them a discount for the second app. If they do duplicates, we give them a bigger discount because one of those is going to be dropped, and I'll explain that in a minute. So a duplicate app bypasses the lottery altogether. We follow that December 20th. And the lottery doesn't start until January 1st. So that application, we match these 2 applications. I call them insurance apps or duplicate apps. And so we're going to do 11 entry with a 3/20 start date. And sorry for my messy writing. And we'll do 10 qualified. And now, it's important to know, at 3/20 there are no new visas available for Mexico or any country bringing new or returning. There's only Northern Triangle visas available, but they were available right now. If you wanted to bring Northern Triangle workers, it's September 20th, there are still Northern Triangle visas available to bring workers right now. And so those have been lasting all year. They almost ran out this year. I thought they would. I'm certain they'll run out next year, but still they won't run out till summertime, midsummer or something like that. So if you split your applications into 2 double apps and split that number, 11 or 10, you can even bring your most experienced workers on an entry-level app. And what we do is we take the pay range and we overlap them to where what you want to pay is in that overlap. And so either worker, your guys that you're wanting to bring up, and when I say that, most of our clients have been bringing workers from Mexico for years. And I hear it all the time. Get me my guys, and we do our best. As you can see, we use strategy to try to get you your guys. But in the unfortunate event, if we don't get you your guys, because we don't control the lottery, and if both of them get in you get a group E and a group G, you're not going to get those guys from Mexico on that app. So we do everything we can to get you your guys, and by doing double apps and getting a 75% chance of getting one of them in there. So if only one gets in, maybe the entry level, and you can bring your experienced guys in on an entry level app as long as you're paying them the right wage, and they can be overqualified. 11 of your guys are coming up, early, April 1st. They're coming up on time and everything. The qualified, you might still be able to bring some of the guys on the returning worker cap, but you might not. You might have to bring up Northern Triangle if this one's a Group G and this one's a Group A, but at least you're getting some of your guys up early in the season. And then you could use this one. But if this one got a Group G, so let's say this one got a Group A and this one got a Group G. And so what you would do is you'd bring up your guys from Mexico on that entry level. This one's not going to get reached until May sometime. And so that's too far out to get your guys. What you would want to do then, if you got a Group A here, you would cancel this duplicate app. One of these is going to get canceled. In that case, a Group G, you don't want the Group G. You'd rather bring them up on 3/20. If you're going to have to use Northern Triangle workers anyway, you want them in March, not June, right? And so you would cancel that one. And so you're basically playing the game wisely to where you're having the best odds of getting what you want, but either way you're getting workers. Now if both of these got in one of those later groups, you'd still be able to bring up all your workers in March. But they're not going to be, the guys that have been coming from you for Mexico for maybe, 20 years or something like that. And then we can do transfers and things to try to get you some of your key guys. We have strategies for that too. But this is going to get you the best odds of getting your workers. You can know that regardless of what happens with the lottery, even if you have to go to the insurance apps, you're going to have your guys or workers early in the season to where it's when you need them. So anyway, I wanted to show you that. We'll go into more of this a little bit later. But the reason this makes sense is then you can go ahead and take your contracts. You know I'm going to have labor. It's going to either be late March or early April. I'm going to have the labor I need to work these contracts. I'm not depending on the lottery. You know, I'm going to play the lottery, and I'm going to try to win the lottery. But even if I don't, I'm going to have my labor. I can take those contracts. I can train those guys. I'll have the manpower I need. So we recommend these strategies. Jackie Katzenell with Landscapes USA is going to be sharing right before lunch on how successfully they used it. And I think out of 15 they had 5 Group A's. Is that right, Jackie? And then several other Group B's and everything, and had all the labor they needed. And then they transferred them around to different offices that didn't get in the lottery, and had all of their offices staffed more than adequately. A lot of times people see Brightview or some of these other large companies getting their workers every year, and they think they must be bribing the Department of Labor officials, you know, because they're always getting their workers. But they're doing the same thing. This is what they're doing. But they have more offices. They have like 100 offices. So if you look, I have a list of all the companies and the groups that they were in each year. And they're getting Group F and Group G and Group C, but they're getting Groups A and Group B and everything, because it's just those groups, and it's randomized, and it's kind of a game of chance. But when you are doing more applications, you've got better odds of getting some of them in those early groups. And so they're getting the labor they need, and then the other ones they might bring up, you know, from Northern Triangle, and they're developing an alternative labor source. And this is what I recommend that my clients do. You got your guys from Mexico, you train them, you want them and everything, but what you want to do is you want to start bringing up and training a secondary labor force from Northern Triangle, because they have approved, this last year, they approved 20,000 visas just from the Northern Triangle countries. And that's Guatemala, El Salvador, Honduras, Costa Rica, Colombia, and Ecuador, and Haiti. And so those countries have 20,000 visas that are not even being used up every year. And so that gives you the insurance of knowing, worst case scenario, I'm going to bring my guys from Central America up. You know, if I can't get my guys from Mexico that have more experience, I'm going to start bringing up a labor force from Central America that's also trained, that knows our business, and I'll bring some of those up every year from each location, so that if I can't get my guys from Mexico, I have a backup labor force that is trained and knows my business. All right, a little bit about our law firm. I mentioned I started doing this in 1998, and so 26 years ago now. And I had a friend of mine, I was doing civil trial practice at the time, and by the way, my friend, which is, he wouldn't mind me saying, Greg Maffitt with the Grass Patch, he was my first client, and we knew each other from church. And I was doing civil trial practice. I had about 50 cases at a time. I was working 7 days a week, and he was calling me like every day and saying, Bob, I want you to get my visa guys for me. I'm paying a lot of money for this. I'd rather use you. And I kept saying, Greg, I'm too busy. I don't have time for that. And so my wife was my only legal assistant at the time, and she had walked out and slammed the door twice, saying, I'm not your secretary, I'm your wife. And I'm thinking, okay, I need to get into something else. And we didn't really like working 7 days a week and the trial practice and everything. And so kind of the light went on, and I thought, well, maybe I ought to try this visa stuff that Greg's asking me to do. And so he sent me 2 friends of his. I did 3 clients in 1998. The next year I had 42. The third year I had 100. And at that point I wasn't doing civil trial practice anymore. I was just doing visas. We'll do close to 400 applications for over 5,000 visas this year. And we're not taking all the business we can. You know, we're just taking, we have 8 of us in the office. I'm going to introduce everybody here in just a moment. And And we have highly trained legal assistants. They all go through months of training before they ever touch an application. And we have managers that are very experienced. We have our best team this year than we've ever had. And we've had some real good people, as y'all know. But as far as the overall team, we have, I would say, our best team ever. And so I'm the attorney in the office. We might be adding another attorney in our office within the next few years. I have a friend of mine who's in Houston who we are talking about possibly joining our team, and we'll look at that. But not doing anything different other than just adding an attorney on and legal assistants as we need them. So I'm going to invite everybody to come up. John, Jonathan, everybody, Emily, Lachelle. And Emily's been doing our H2A applications. That's my wife. And she has been wanting to retire for a number of years. So this is her last year. She's trained Nicole to do the H2As. And so all of you will have a trained legal assistant. The advantage of having a trained legal assistant, I talk to a lot of people that have been with somebody else and they call up and they can never find out the status of their application. They switch them to somebody else they don't know and everything. We always have a trained legal assistant that is your legal assistant, that if you want to know, hey, do you need anything from me? You call them up and they know everything about your case. We don't do work from home stuff. We're Monday through Friday, 9 through 5. You can reach your legal assistant, and if they can't answer your question, I'm available to you as well. And so I'll start over here. This is Sophia, and Sophia does H2B and is in her third year now. And then doing a great job. Emily, my wife, who, even though she slammed the door and quit, she walked out twice. I walked out the door. It's like, I'm not your secretary. And I remember thinking, some of y'all remember Courtney Cruz. She was a legal assistant of mine. I lost her to children. She got married and had kids. But so she was my second legal assistant. Christine Sampson, who's John's daughter, was my first legal assistant. And when Courtney came in, she was interviewing, and she said, she was right out of high school, and she said, all I've ever wanted to be is a secretary. And I said, you're hired. And she's a real good legal assistant. But anyway, and then Lachelle Overton, and Lachelle, this is her second year. John Sampson, who's Christine's father, and he is in his third year. Yeah. And then Evelyn Serna, she's our managing legal assistant. She's in her fourth year. And then Nicole is, you're going to meet Edgar, her husband, a little bit. He's doing processing in El Salvador, Guatemala, and Mexico. But Nicole, she's in her first year. She's doing a great job. And then Jonathan is in his second year and doing a great job. And so this is our staff, and wanted to introduce them. And so if you would, if you know who your legal assistant is, try to say hi to them during the lunch break. All right? All right. John also does all of our IT stuff in the office and keeps us running with all our technology. And he's also, I also pastor a church here in Austin, a small but growing church, and he does our IT in the church as well. So he does double duty, as do a lot of the people in our office. And then, so we've got their emails there. If you need a business card from them, you can grab a business card. But you call one number to reach any of us. I've talked to a lot of people that used other law firms or other processors that said they could never reach their legal assistants, that they'd get on some rotary deal, leave a message, and, if you want to speak to this person, dial this, if you want to speak to this person, dial that. And they could never reach a live person, and so they'd leave messages and nobody would call them back. The only time you won't reach one of your legal assistants when you call is if they're on the other line. and the legal assistant that answers will get a message, get it to them, and they'll call you right back. So same thing with emails. We do our best to turn around emails and calls within 24 hours, whenever possible, same day. So what's included in our H2B retainer price? One thing that we offer that a lot of people don't out there, we offer legal consultation and representation for the entire year. So even after the workers get here, we've basically fulfilled our contract as far as the application is concerned, but I continue to offer legal advice and legal service to my clients throughout the entire year. So you have a question that you're not sure what to do, you can call me up. I'll tell you what the right thing to do is. And your legal assistants can answer usually about 95% of your questions. So you don't even have to go to me. You know, a lot of times they'll have the answers for you, but if you need to go to me, I'm available year-round. But in addition to that, we give you an initial consultation where we look at your company and your needs, and we offer advice concerning what will best meet your needs. We do all of the filing of all the paperwork, filling out of the paperwork. All you do is sign them, review them, and sign them. We obtain the prevailing wage determination for you. We file the H2B application. We place the job order with State Workforce Agency. We advise you on recruitment and how to do that. If you get a notice of deficiency, which means they have questions about your application, we respond to that effectively to be able to get you moving on immediately. We give you assistance in the U.S. worker recruitment process. If you get a request for information, we respond to that to the Department of Labor. We file the USCIS petition, draft all of that, put all of it together for you. We forward your approval to the consular processor, and we give you advice during consular processing if necessary, and legal advice through the entire process. There are some things that aren't included in our price because it would drive everybody's prices up. Main thing that is not included in our base price for the application is if there are audits or investigations. We'll get into that further later in the presentation, but there are more of those going on. I do represent people, but it is an additional fee for an audit or an investigation, and I try to keep those fees reasonable as well. So a few things that aren't included: if you get multiple prevailing wage determinations, if it's just one, I'll usually go ahead and do it, but if sometimes people are trying to kind of test the waters in different areas, and we end up doing a lot of them, we have a small upcharge for that. If somebody appeals a prevailing wage determination, it's very rarely done because they're pretty much set at this point, but that's not included. If we have to open the State Workforce Agency account for you, we charge for that, but it's we can walk you through it, and we do. So they're not hard to set up, and most people already have it. We don't cover the U.S. recruitment mail costs, though they're not really, you don't have to do much by mail anymore. It used to be we did everything with certified mail or overnight mail. We don't really do that so much anymore. Overnight delivery, we have a FedEx fee that is included in our fee, but then if there's more, we charge for additional ones. Appeal of a DOL denial to BALCA doesn't happen very often. The only time I've had to appeal one, we won it. And then DOL visa fees for H2A, that's additional. It's $100 for the application and then $10 per worker. Additional, more than one I-129 application. There's one I-129 application petition included in our cost, but then if you have to split that to do some Northern Triangle, some U.S., or some transfers, some coming through the consulate, we charge for the additional. It's just $300 for the additional I-129. Most people just do one. USCIS filing fees, premium processing, asylum fee, and fraud prevention fee. Those fees have gone up a little bit, and they've added that asylum fee, which we'll go over in just a little bit. And then responses to RFEs. If they're minor, that's included in our cost. If it's something that they're really going into the company's business, there's a small charge for that, but most of them will cover at no additional cost. Appeal of a USCIS denial doesn't happen very often, but we would charge for an appeal. Audits, investigation, investigations. We're seeing more of those. Just to give you an idea of my clients that got audits or investigations, even with them going up, we did not get even anywhere near 10%. Probably down around 5%. I haven't actually counted them, but I'd say it's probably about 5% of our clients got either a paper audit or an agent showed up and wanted some things, and they're usually not very thorough. They're just kind of monitoring and testing for compliance. The main thing, if USCIS shows up, that they want to see is that the workers are actually there doing what they're supposed to be doing. But USCIS, they're not really as difficult. DOL can be a little bit more involved. I do suggest that you get our representation in that, because the advantage of having me represent you in an audit or an investigation is if I'm representing you and you tell the auditor or investigator that I'm representing you, they won't contact you anymore. They'll go through me. They're required to if there's an attorney representing you. And that can be a plus, because a lot of times they're asking you kind of trick questions. You might not realize that they've got another motive in what they're asking you. And I know what we need to tell them and what we don't. And, I can always say, well, let me get with my client and I'll get back with you. It just puts a little buffer between you and the investigator. And we try to keep our costs pretty reasonable on that. We do offer attorney-conducted compliance audits, and we have usually 1 or 2 clients per year will offer me, usually about 1, they'll want me to come out and do a compliance audit at their place of business, make sure they're doing everything correctly. I'm happy to do those. I do charge for them, but I come in just like I'm a DOL agent, and I come in and I ask the same questions. I'll use the same forms that they use and everything, and we'll go over all that paperwork and see if you're filling it out right and your records are being kept properly. The recruitment of H2B workers, the employer does that through our consular processors. You'll meet them after lunch, but the employer does have to pay for those fees down there, the visa fee, the consular appointment fee, and the transportation and subsistence costs, and the processors, what they charge, and if they're doing recruiting. They're very reasonable. Once you are down at the consulate, you've already been approved at USCIS. On average, you're going to pay about $650 per worker for the consulate fee, the processor, the transportation, round-trip transportation. But you're paying that usually about 2 or 3 days before the workers arrive. And then we do have a Seasonal Employment Alliance lobbying fee of $10 per worker. I've joined that for the benefit of my clients, and so these additional visas that we're getting now every year, these supplemental visas they call them, some of them are returning worker visas, some of them are Northern Triangle visas. Those are being obtained and have been obtained through the Seasonal Employment Alliance. So that's a huge benefit, because it's about double the number of visas available. So that's a huge deal, and we support them. And one of the advantages of that $10 per worker fee that we charge, that goes entirely to them. I don't make anything on that. That's what they charge me for being a member as a processor. But you get all the benefits of the updates. You get all the benefits of if we're doing a fly-in or something like that. I update you on that and tell you, when we're going for lobbying. And they're doing a good work. And so we're all benefiting from that. So if you're bringing 10 workers at $10 a piece, you're paying $100. And if you were to be a member, it'd be thousands of dollars times all of y'all. And so we just spread it out at $10 per worker, and that gets you the benefit of membership. You can even be on the conference calls that they do every couple of weeks. They have a conference call with updates. You can be on those as one of my clients if you want to, or we'll just get you the information, as you need it. Coming out from those, but they do a lot of lobbying. They're very, very much, having their thumb on the pulse of what is needed for the industry, and are lobbying for that. And so that's a $10 per worker fee that we have in there. All right. Just FYI, we're going to take at about 10 o'clock. We'll take a 15-minute break. And I think we have some pastries and coffee. Everybody can kind of meet one another. We'll take a 15-minute break here about 10 o'clock. So our process is we do an initial attorney consult, If you need a consult, and maybe you've been consulted, but you need a consultation on something else, especially now until January 1st, I'm available to consult with you about any questions you have. You want to increase the number of workers or move dates or something like that. They do have guidelines on that now. You can normally only increase the workers by 20% a year and dates by 2 weeks per year, but I'll consult you on those types of things. We have information letters that guide you through the process. So when we get your notice of acceptance, we give you the entire process on recruiting U.S. workers. It's not difficult, but we give you detailed instructions on how to do that. Any interviews that you might do, how to document that properly so that when we give you recruitment results, we have everything we need. And then those information letters guide you through the entire process. So even if you've never done it, it gives you detailed instructions. If there's something on those information letters you don't understand, you can of course call your legal assistant or myself. The attorney consultation concerning supporting documents, dates, and number of workers if necessary. We give you an assigned legal assistant, so you're just dealing with one person. We do the seminar. I don't know anybody that does this seminar or anything like this. And this handbook, through the year, you have a lot of information here that as you have questions, your legal assistant can tell you, oh, that's laid out in detail, just look at page 33 or something like that, and everything that you're asking is right there spelled out. So you'll have a copy of this, and even people that don't come get a digital copy. And then we have our own consular processors that we use, and we've added Valor International Processing this year. Edgar and Tony are doing a great job down there. So Solstice International, Monarch Butterfly, Helping Hands Consulting in Guatemala, and VIP, Valor International Processing. They're in Mexico, El Salvador, and Guatemala, soon to be in Honduras. So we have boots on the ground in these places so that you have processors that we know are reputable and their prices are competitive and good, honest people. And so as far as the application process, I'm on page 6 right now. The basic steps in the H2B process, we've got to request a prevailing wage. They're taking 45 to 60 days on prevailing wage requests right now. This is another reason we try to get everybody signed up and their paperwork started early, because we can't even fill out the application till we get the prevailing wage request back. I mean, we could try, but there's a lot of information that we don't have until that comes back to us and it's been approved. And so with that taking up to 2 months to get that back, we have to start early to make sure we have enough time to do your application properly. So we request the prevailing wage. There will be registration normally starting in August, September, once they start that, but it's not implemented yet. We do file the application during the fall. We're putting your whole application together and filing it January 1st through 3rd or December 20th if you're doing a March 20th start date, duplicate app. We process the NOA or NOD depending on which one you get. Of course, eventually you get an NOA. We help you in the recruitment of U.S. workers. We help you draft a recruitment report where everything's correct, should go through fine the first time. We get the final determination for labor certification for you. The petition to USCIS, we draft all that and get that in as quickly as possible. We overnight it into USCIS. That's a paper copy still. Once the visa is approved, we get those down to your processor and make sure that you get the first appointment possible. We help you in consular processing. We did have a few hiccups this last year. We had one processor that got sick, was in the hospital for several weeks, and we had another one that had some delays and because of the consulate. And you should have gotten an insert in the back, and I'm just going to go ahead and mention this now. I'll briefly mention it again when the processors come up. But we have a memorandum of understanding now with our processors. We have real good processors. They know what they're doing. But we want to make sure that our processors understand that we have an investment in our clients, and we want to give good customer service and make sure our clients get their workers on time and with no delays. And so we have a memorandum of understanding with our processors now, and you can take a look at that. But it basically says that we and our processors, we want to make sure that their calls or emails are returned within 24 hours, basically that they're getting reasonable status updates, kind of knowing, when their appointment's going to be, what's being done to get their workers in as quickly as possible and getting them to you. We want our processors to explain if they are not able to obtain an appointment for workers within 3 weeks. 3 weeks might sound like a lot, but in the peak of processing, especially the consulate in Monterey can really get backed up. So all of our processors in Mexico will try to shop those to different consular posts. So they might be in Matamoros, they might be in Mexico City, they might, there's over a dozen of them in Mexico. They'll try to find ones that have the least waiting period. But just to make sure that you have options, I've asked our processors to agree that if they can't get you an appointment within 3 weeks, that they will give you the option of trying to use somebody else and see if they can. So they won't just hold on to you, because you've paid them or whatever. They'll refund your money and let you see if somebody else can. Normally, if they say, look, I got you an appointment in 3.5 weeks and you're not going to get anything quicker, we shopped it around all over the place, you're better off just staying with them because they've already shopped it and everything, but we want you to know you have options, and you could try to see if somebody else can get one quicker. Then also only offering terms to the workers that are on the job order. This is something that has become a big issue now with these audits and investigations. If you look behind that memorandum of understanding, there's a copy of a job order, which if you've done this, you're familiar with this. And I whited out the name of the employer and everything on this one. But this has become very important. If something's on this job order, Department of Labor views it like a contract with the government, basically, that you're going to do everything that's on here. And so sometimes the workers are wanting something that is not on here. This cannot be changed. Once this has been submitted and been certified, nothing can be changed down at the consulate level or anything else. That's the job offer. One thing that we're going to be talking about a little bit later is that the housing arrangement needs to be much more detailed. If you're doing anything to help them with housing, if you're paying part of it, if you're advancing them money against pay so that they can get housing, if you're basically renting it for them or offering discounted housing, whatever it might be, it needs to be on the job order. And those details need to be on here. They cannot be changed later. And so during the process, we have to start in advance making sure what the job offer is, and that is it. And so we make sure that nobody's going to try to change that even down at the consular processing stage. And then also if in any case the processor has circumstances that have changed that would cause disruption or significant delays, our processors agreed to refund your money so that you can go somewhere else. And that had never come up before, but we did have a processor this year that was in the hospital for several weeks. And so we just want everybody to know that if there are unnecessary delays, that they can go to somebody else and their money will be refunded. So we're doing everything we can to make sure that you get your workers as quickly as possible. And by the way, every one of our processors have signed that memorandum of understanding. Okay, and then the request for the prevailing wage determination, I won't spend a lot of time on this. They're good for up to 1 year. They will take up to 60 days to process, so we do need to start early on them. They will be submitted by us in September or October at the latest. They're based on the mean wage, which is just for H2B. That's what it's called, the mean wage. But it's a prevailing wage. There's no wage surveys anymore. They've pretty much done away with that. And it's very important that the employer needs to communicate any range in pay to us before we start the application process. And so what I mean is, if you have U.S. workers, some of them are very experienced and they're making $21 an hour, and your prevailing wage is $17 an hour. Your range of pay is 17 to 21. And you might say, well, I don't plan on paying my U.S. workers, my H2B workers 21. It doesn't matter. That's what this position in your company is getting paid. And we can even play with those wage ranges to make sure that we have the overlap we need to where either application, entry level or qualified that you're doing, that overlap is where you want to be paying these H2B workers. But we need to make sure that that is accurate, because if they come in later and investigate you, and maybe you're paying some guy $23 and the highest you had on your job order was 20, they'll say, oh, you're preferring U.S. workers over the foreign workers. You can't do that. If U.S. workers would have known if they have experience, you're paying 23, you would have gotten a lot of U.S. worker applicants, which we know is not true, but that's their story. And so they want to make sure that whatever you're paying. Would you do me a favor? Write down your questions, and we'll give you, right before we take a break, we'll take time for question and answers. Because if I stop for all of them, I'll never get through the presentation. And so I'll try to get as much progress as I can. Then right before the break, right before lunch, and right before the afternoon break, and right before the end, we'll take the questions. So yeah, the wage range. You want to go to the lowest paid worker to the highest paid, and then the qualified versus entry level, they'll be a little different. The qualified will get a little bit more, and you want to the highest you would ever pay an H2B worker should be the high end of the qualified, but we want to make sure you have the right wage range there. And that needs to be communicated. Application is 75 to 90 days. We'll file it right at about 90 days during that filing window. We don't want it to be 75 days. We want it to be as far out as possible so we have time to get everything done. And you should do separate applications for different dates of need. So if you have a peak within a peak, that requires a separate application. If you have different positions, what's having to be done right now a lot with landscaping is if you do a lot of hardscapes and you do a lot of cement work, on outdoor kitchens or something like that, you're going to have a masonry application. Landscape laborers cannot touch wet cement. They can do segmented paving. They can put segmented paving in for patios and stuff, but if there's cement work being done, there needs to be a masonry application for the ones who are doing the masonry work. It's going to be a higher wage, but landscape laborers cannot be touching, and I don't agree with it, but I don't make the rules. I think the hardscapes should be just like another landscaping laborer. But if they're doing patios, they're doing, outdoor kitchens or stuff like that, they're doing maybe retaining walls and things, and it involves concrete, they're going to want separate workers who are doing the cement work. Those are masons in their view, and they get a higher prevailing wage. So if there's different work that they're doing, different positions or different skill levels. They used to have 4 skill levels. Now they only have 2. Actually, we've created the 2 skill levels so we can get double applications in there. The skill levels for H2B have been done away with, but they'll still allow 2 skill levels, entry level or qualified, to be able to do 2 applications, because they understand some need to be entry level and some need to have experience on a crew. And if you're doing different areas of intended employment, we have clients that have operations in Austin, Houston, and Dallas. Unfortunately, that's applications for each of those areas because there's different wages for each of those areas. And if they're doing double or triple or quadruple apps, they need to consider that for all of those locations. So different areas of intended employment. I've shared the double app strategy for getting in Group A through C. And the strategy this year for avoiding the lottery, duplicate apps. We're on page 7 now. We do respond to the notice of deficiency. We give you directions as far as the notice of acceptance. Once you get a notice of acceptance, you're also going to get a registration number, which is valid for up to 3 years. And that's going to help you rush through the process once you have that registration number. If you change anything major on your application, you'll lose the registration number. It won't apply. So if you're doing different counties, you're adding a bunch of different job duties. If there's been any major changes, if you go outside of 2 weeks in changing your dates, you'll lose the registration number. But if everything is substantially the same as the year before, they're going to allow you to be approved automatically pretty quickly. As soon as your group gets up and you get, they review your application, you're going to get an NOA immediately, notice of acceptance. Amendments to the application or job order are allowed prior to the final determination. We don't see that too much, but there can be amendments. And then the recruitment is the most important step in the application process that the employer can really help their chances of getting in before the cap is reached. And the reason that's still important, when the April 1st start dates are being reached, we're applying for April 1st, there's so many people applying that you still have to run that race well during the recruitment period. And so, to give you an idea why that's important, there are several caps and you want to be in those first 2 caps, especially if you're bringing workers from Mexico. So the first cap is the 33,000 visas from that were approved by Congress years back, and those are workers from any eligible country, new or returning. And so if you're in that first 33,000 cap, you're going to be able to bring your workers from anywhere. You'll be able to bring them from Mexico. They can be new or returning if they're in that first 33,000 cap. Everything over and above that is supplemental visas, but there's still different caps in the supplementals. So the second cap, after those 33,000 are gone, are going to be for returning workers only. And it's also any eligible country, but they have to have been on the program in the last 3 years. For most of my clients, either of those caps are good. And so you got 33,000 plus an additional 19,000 this last year that are going to get you those workers from any eligible country that have experience, have been coming up for you for years. And so that's pretty much groups A through C and some of D are going to get you those workers that maybe you're wanting to bring from Mexico. They've been coming up for years. Anything after that, so the returning workers is 19,000 this last year. 33,000 for new and returning from anywhere. Then 19,000 visas for the returning workers only. And then the other caps are going to be Northern Triangle. And they had 20,000 for Northern Triangle. And then they put another cap, which is May 15th. Late start dates, anything after May 15th is a late start date. They got 5,000 visas this last year. And so there's these different caps now, and where most of my clients will want to be is somewhere in groups A through C and some of D. That's where you want to be. And if you want some new workers and returning and maybe from Mexico, you'd want to be in groups A or B. So C is going to be in the returning workers, and let's say you're wanting to bring some new also, then you'd want to be in groups A and B. And so that's why there's an importance of rushing your application. So there's still a race to get in before the cap. And the recruitment is where you can save time. You can take weeks, like 4 weeks to do the recruitment, but you're going to get capped out. You can do the recruitment in as little as 15 days if you're open 7 days a week to receive applicants. And so during the recruitment period, you want to be open on Saturdays and Sundays. Just have somebody there in case somebody stops by and says, I saw your job posting with the State Workforce Agency. I wanted to come by and apply. If we can put on your recruitment report, you were open 7 days a week, we can get that recruitment done in 15 days as opposed to 15 business days, which could take in 2 weekends and add 4 days to the timeline. If we can get it done in 15 days, you'll pass up a lot of people that are taking their time on that recruitment report. So we try to get it done in 15 days, and on that 15th day, we're submitting your recruitment results. And usually there's not too many applicants. And so that's real important to do it in 15 days by being open 7 days a week. You've got to contact prior employees now and offer them the job position usually in the last year. If they've been with you in the last year, you need to offer them the job. Employment interviews can be by phone or at your location. They could add additional recruitment. They aren't doing that really very much. The job orders need to be thorough and need to be exact. The recruitment report needs to be done as quickly as possible during that recruitment period. Lists there everything it's got to include. We make sure you've got everything on there that you need to put on there. When we send you the notice of acceptance, we send you detailed instructions and we send you templates of the letters that you want to send out to applicants. They're usually emails now. You can just take that template, put their name in there, and email that out. Copy it, on your email. Copy it. Send that out to them. We got your name from the state workforce agency that you're interested in a job with our company. Please contact us within 4 business days to set up an interview, and we look forward to talking with you. Most of the time they will not contact you. They will not set up an interview. But if you get those out, we have the templates there, and then we have the template for the final recruitment letter. If you follow our instructions, it's just all detailed. It's very simple. You just use our templates and make sure that you fill in any applicants that you had, their information and what happened. And that can be done very quickly. You won't have a lot of applicants, but as you do, you want to make sure that you do it as quickly as possible. Then there's the final determination. The certifying officer can approve, deny, or issue a partial certification during reducing the period of need or the numbers of workers. You can only transfer that labor certification to a successor in interest. The Department of Labor's definition of a successor in interest is very limited. And so I had a client this last year who he didn't need the workers anymore, so a buddy of his needed the workers, and he said, sure, you pay him, and you can have my workers. And we find out about it after the fact, and I'm like, you cannot do that. These workers can only work for you. They got to stay on your payroll. But a lot of times people think, well, and I've had this happen this year too. Somebody calls me after the fact and say, oh, we sold our business, and the new owner is they're employing the workers, so everything's good. And I'm saying, well, maybe yes, maybe no. Did the employer buy the corporation, or was it an asset sell? They said, no, it was an asset sell. I said, well, you're not good. That's not a successor in interest. They cannot employ those workers. There's a way to do that. And what I have found, and this is the important thing of having an attorney to represent you in these H2B applications, because most things, as long as you're trying to obey the rules, if you get good legal advice, usually you can do what you want to do legally, or you can make a big mess out of it by not finding out how to do it right. And so normally what we'll do in a situation like that, somebody sells their business but it's an asset sell, we'll say make terms in the sale to where these workers will stay on your payroll for the remainder of this season, and they will pay for it. They're going to pay for the payroll, but they're going to stay on your payroll. That's part of the sale, is they'll stay on your payroll and they'll pay for it through this season. That's totally legal. You do a subcontract arrangement with them to subcontract your workers. They're staying on your payroll. They're still doing landscape duties in the same area of intended employment. You're fine. And but if they go to work for that new company on a different EIN number, that's a big problem. And there if in an investigation or something like that, there could be significant penalties for that. So if you have a major change like that, you want to make sure you're getting good legal advice from us. There can be redeterminations. Document retention requirement. Most of y'all know this, and all the documents that you get from us, if we send you something to sign, you want to always, when you sign it, make a copy of it and put it in a hard copy file. You can also scan that and keep a digital file, but as you all know, computers, can get fried or get messed up and quit, and so you don't want to lose your information if you only have digital files. So make a hard copy file and make a digital file of all the documents through the whole process. We also keep all of your documents, and so if you didn't keep one, and you get audited and they're asking for that document, we have it. And we keep all of them for 3 years. I have a storage unit full of files. If they're going back 3 years, I can get all the documents. But you'll want to keep a document file as well, just to be able to refer to for up to 3 years. Any document like a job order, you want to keep a copy of that. And it gives all the required information, pay, if you don't want to refer to that, months and everything. So, and keep that for up to 3 years. It's called an audit file. And if they show up, if the investigators show up, they'll want to see your audit file and the documents that are required. See where we're at time-wise. All right. Employer obligations and declarations. I'm going to go through these pretty quickly because what I want to stress, there's three things, that are really stressed in these audits and investigations. What I showed you earlier, that job order, they're really going down the laundry list of those things and making sure you've done everything correctly that you were supposed to do on that job order. You're paying the right rate of pay, they're doing the duties that they're supposed to be doing, they're working for the employer they're supposed to be working for, they're getting the hours that they were promised and all of that, or at least up to 3/4 of those hours, and the 3/4 guarantee. But so they look at the job order. They also look at the Appendix B. The Appendix B is what y'all sign, that's the employer promises or assurances of what they're going to do, and they are very similar to these ones we're going to read, these obligations, but they are a little bit different. We're going to go over both, but the Appendix B, all the things that you sign that you declare under penalty of perjury that you're going to do all those things, they go down that laundry list. They go down the job order just like a laundry list. And if you get into the supplemental visas, as you all know, there's an attestation. I've heard of people with other law firms and other processors that the law firm or the processors ask the employer for permission to sign that for them. That's not allowed. But they don't even send them the attestation. They just ask for permission to sign it for them, and they sign it for them. And the employer doesn't even know what their obligations are under that attestation. And so there's a duty of being able to prove and have documents that show that if you don't get these workers, it's going to hurt you financially, or you're going to suffer irreparable harm, they call it, or severe financial loss. Well, of course, if you need workers and you don't get them, you're going to lose business. You're not going to be able to service as much business. So it's not hard to prove, but it's something that if you do get audited or investigated, you're going to have to show those documents that you relied on. And so we give you a copy of that. You sign it yourself, but you should read things that we send you, like the Appendix B and like those attestations, because those are requirements that you're signing that you'll do. And so we do send you the attestation, and they'll go down that as a laundry list as well. So not only is there, a attestation that you'll suffer irreparable harm if you don't get the workers, there's also, if it's over 30 days past your intended start date, you have to do additional recruitment and stuff like that. We do that, most of it for you, but you do have to know that in case of an audit or investigation, you would have to prove that you did the required recruitment, additional recruitment. A lot of times when other law firms or processors are signing for the employer that those things will be done, and the employer doesn't even know what's supposed to be done, many times we have found out the law firm or other processor isn't doing the additional recruitment. And then when they get audited, they can't produce the documents because it wasn't done. I had 12, and it looks like there's another 13th now, clients of mine that were debarred because their previous law firm did not do the stuff they were supposed to do. Let the employer attest to, with them signing for them, attest that the things were done. The things weren't done. They got audited. They couldn't prove it was done, and the employers got debarred and kicked out of the H2B program. We got every one of them undebarred, and we won a precedent-setting case with the Administrative Law Court that oversees Department of Labor. We won a precedent-setting case that stands for if the lawyer was the reason that the things that were supposed to be done didn't get done, that can be cause to exonerate the employer. And we got all 12 exonerated. The judge agreed with us that it was the lawyer's fault, not the employer's, because they didn't even know, they'd never gotten a copy of it, they didn't sign it, and they didn't do it, but the lawyer was supposed to do it, he didn't do it, and we got all 12 of those debarments rescinded. But I'm just saying these things are important, and the employer can be held accountable. They're not really difficult, they just need to be done. You can't just blow it off. I think many times people have, I guess, in the past, but no more. If we say we're going to do something, we need to make sure it gets done, and we will. We'll make sure on our part that it gets done. Okay, employer obligations. The rate of pay has to be at least the prevailing wage. You need to be paying them at least that. You also need to make sure that if they're working over 40 hours, they're getting time and a half for H2B. H2A does not have to pay time and a half for over 40 hours because it's agricultural work, but H2B does. You don't want to get a wage and hour audit or not be paying overtime, because back wages are not waivable by the Department of Labor. If they find out you have not been paying the wages you're required to pay, they must collect those, and there's probably going to be civil money penalties. So you want to make sure that you're paying the workers properly. You have to be paying them at least the prevailing wage, and if they're working over 40 hours, you have to be paying them time and a half. The wages have to be free and clear. You can't be holding on to their wages for different things unless there's deductions that are on the job order. The Department of Labor's position on deductions is if they're not on the job order, they're not allowed. And we'll go over that in a little bit, because if something changes and deductions weren't on there and all of a sudden deductions start being made, they'll count those as back wages. And so you don't want to start doing stuff that aren't on the job order, especially in the area of deductions. You want to make sure the wages are correct. It needs to be a full-time opportunity. Full-time for Department of Labor purposes in H2B is 35 hours a week. You're only obligated to do 3/4 of that. So if you have rain days, bad weather, so let's say you're offering 40 hours a week. The 3/4 guarantee is measured over 3 months. The workers get here, the next 3 months, you're going to have to give that worker at least 3/4 of the hours offered. So that equals 30 hours for a 40-hour week. On average, over that 3 months, on average, you're going to have to have paid at least 30 hours a week. Otherwise, they get a guarantee. Now, I think for most landscaping and construction, that's not a concern, because you're going to be working them even overtime. So just so that you understand, I've been doing this all these years. I've never had a client have to pay the 3/4 guarantee. So my clients are using their workers, overtime. They're not really worried about that 3/4 guarantee. They've got them out there working and making hay while the sun is shining. So, but even if you get some rain days, or I remember, what was it, about 5 years back, we had a month here in Texas that it rained. I forget what year it was. But even in a situation like that, you're going to be able to recoup it, even if we have a good long rain 1 month, you're going to be able to recoup it in those other 2 months. So it's a full-time opportunity, at least 35 hours a week on the job order. and there's going to be a 3/4 guarantee. And there are job qualifications and requirements. You can't use landscape laborers and have them doing carpentry or something. They have to be doing the job that is on there. The 3/4 guarantee, I just explained that, but there's a 3/4 guarantee that at least 3/4 of the hours offered on average every 3 months are going to be guaranteed to the workers. Impossibility of fulfillment, that just means if your whole business gets wiped out with a tornado, God forbid, that you are not held to the job order. The certifying officer will let you off on the if requested under those circumstances. Frequency of pay. You have to pay the workers at least every 2 weeks now. You used to be able to go semi-monthly. That's no longer allowed. So you can pay weekly or you can pay bi-weekly. But you can't pay semi-monthly or monthly. It has to be at least bi-weekly. Now, the earnings statement, this is a requirement. It's got a list, hours worked, deductions, taxes taken out, the employer's information. There's a laundry list of things, which we'll go over in just a little bit, but those things do have to be listed on the earnings statement. I was talking with a client earlier this morning that they were audited, and the only thing that they found them not doing was putting on the earnings statements hours offered. So you have to put hours worked. But they have a requirement that you have to list hours offered. And it's very hard to put that on an earnings statement because QuickBooks and ADP, they don't have that, right? So how do you keep track of that, the hours offered? This investigator, I'm not advising this, but this investigator told my client that you can look at the previous year and see on average how many hours they worked during the same period of time. I'm not advising that because I don't agree with that investigator or auditor, because it's supposed to be for the year in question, not the previous year, that they're getting that, but they said that they would take that. And the best way actually to do it on an earnings statement is to, if you're using the sheets, the time sheets and everything, like if your crew leaders saying what time they started, what time they stopped, and all of that, and the workers that were there for that day, he can put hours offered. I'm not going to get into the 3/4 guarantee. We have an exhibit in the back because it would take quite a bit of time. But basically, if you offer extra time, like overtime, if they work it, you get credit for that. But if you offer hours outside the job order and they don't work it because they say, no, I got to go at 5, you don't get credit for offering it because it wasn't on the job order. So there's a lot of fine lines in there, but really it's almost moot point because most of my clients are working them overtime and it's not an issue. Like I said, I've never had a client that had to pay out money for the 3/4 guarantee. The only time you'd have to worry about it really, I did have a client that was planning on laying the workers off early because they lost a contract, and that was this year. But he was getting advice from us on when he could let the workers go, not to run afoul of the 3/4 guarantee. And so, he wanted to make sure he'd paid them enough to where at his last 3-month period where he could let them go a little bit earlier and not run afoul of that. So if you're going to be laying off workers or something, let us know and we can calculate it and make sure, advise you as far as not running afoul of that. But I've never had it happen. 3/4 guarantee. Earnings statement. Transportation and visa fees do have to be paid by the employer. Employer provided items. The employer does have to provide all the items that the worker needs to do the job, like you're providing the mowers and the blowers and the trimmers and all of that. Where you run into a little bit of problem is things like uniforms. That's a little bit of an issue. There's ways to do it. There's ways to do it incorrectly. And so, if you do require uniforms, you might want to talk to us about that, how to do it correctly. If you just charge them for it and you require it, that's going to be a problem. So if you do uniforms, talk to your legal assistant about that or talk to me about it. But most items that are required for the job, the employer is required to provide. Disclosure of the job order. The U.S. workers have to get a copy of the job order. The foreign worker has to get a copy of the job order. They should get a copy of the job order before they process at the consulate, but they also need to get a copy of the job order when they arrive at work in case they didn't get it down there. They need to be giving it to them during your orientation. When the workers get here, you want to go over that job order with them and say, here's the job offer and all of that, and give them a copy of it. That's required now. And to the U.S. corresponding workers. There is a poster that's required to be posted by your time clock or whatever. It's Exhibit 18 in the back, and it looks like this, and you can just rip it out of your handbook and put it on by your time clock or something. You would want to do it in English and in Spanish, and this is required. It says, rights, employee rights under the H2B program. That is required to be posted. And you want to make sure that you're doing everything on there, and you want to make sure that even requirements that aren't on here are being complied with, because they can come up in an audit or an investigation. We're going to show you everything you need to do to where you don't have to worry about that, and they're not really difficult. They just have to be done. But this employee rights poster does have to go up, and it should go up in English and Spanish. We have an English copy and a Spanish copy there for you. And excuse me, I lost my place here. Okay. No unfair treatment. You can't discriminate, and you can't retaliate. If somebody complained, and you can't fire them because they said they weren't being paid overtime or something like that. I've never had that be an issue. And the discrimination stuff you have to watch, not because you're discriminating, but it can be considered discrimination. So if you're paying U.S. workers differently than you're paying the foreign workers, or vice versa, a lot of times you're offering housing to the foreign workers, but you're not offering housing to the U.S. worker. Well, we have a way of fixing that. The way we do that is in your job order. We say low-cost housing. Let's say you're giving them housing for $100 a month, but you're not offering that to your U.S. workers. That's a discrimination issue. But what we do is we put on the job order low-cost housing at $100 a month for all relocating workers. So you're offering it to your H2B workers that are relocating, and if you get somebody that sees your job offer in New York and wants to move here to take that landscaping job, which has never happened, but you have to offer housing to them as well. And so you want to avoid discrimination. And we've run into the issues, where that's happening. Another thing where you run into it is pay. You just got to make sure that you're paying the workers not the same, but the same pay structure applies to all the workers. So if somebody, a U.S. worker, and you say a U.S. worker that's been working 10 years gets $21 an hour, then if you got a foreign worker that's been working 10 years, he gets that same pay. So you want to make sure that the same structure applies to both U.S. and foreign workers. It's not necessarily the same pay, it's just the same pay structure. No unfair treatment, then also prohibitions against employees paying fees. It used to be that foreign workers coming up to work, this was back in the early 2000s and 1990s, it used to be that some employers charge our fee and all the fees to the foreign worker. They had to pay their transportation, they had to pay all the fees related to bringing them up. That's no longer allowed. And it was considered back then that getting the job was for the benefit of the employee. And because it was for the benefit of the employee, and there were court cases on it, you could allow those fees to be paid by the employee, by the foreign worker. But the court cases have changed over the years, and then they solved the problem altogether back in 2015 by in the regulations stating that the employer had to pay all those fees. So now there's no longer any question about it. Even the Fifth Circuit, still in the Fifth Circuit and the courts, they still consider foreign employment to be for both the foreign employee and the employer, but the regulations state that the employer has to pay those prohibited fees. So my fee, the processor, the consulate, the transportation, all the costs involved in bringing that foreign worker up here are now paid by the employer. I had a client this last year that he's been in the program for like 10 years, and he was charging the worker for their bus fare. And I called him and I said, look, you got to refund that to him. And he did. He gave him a money order and refunded it. But that's just not allowed. It used to be, but it's not allowed anymore to allow them to pay their own transportation and some of the costs involved in bringing them here. Again, when I said $1,500 per worker, that includes everything. You're going to be looking on average, depending on the number of workers. If you do more, it's less. So if you do more workers, it's less per worker. If you do less, it's more per worker, because some of the fees are fixed. My fee's fixed no matter how many you do. USCIS fees can vary, but they're fairly fixed. And then the per worker fees are only the consulate fees. That's about $650 per worker. If you add them all up and average them, on average, it's about $1,500 per worker. And so, you know, they're not that high when you consider the benefit of having that worker here for 9 months, but those costs do have to be borne by the employer. And not only can you not charge those workers a fee for coming to work, nobody else can charge them a fee either. So you have to have a fee agreement with your processors that says they will not charge them a fee, nor any of their employees or agents will charge the worker a fee. The reason that happens, if you just write it down, the reason you have to get that agreement from your processor, and not just your processor, but let's say you are sending a superintendent or a crew leader down to hire from their whole village, you know, you better make sure that guy signs an agreement that he will not charge a fee, because it's very common for that person to go down there and say, okay, give me $200 each and I'll put you on the list, you know, and he's charging them a fee. That can cause real problems, because they'll impute that to the employer if they don't have an agreement with that person who was charging the fee. And so recruiters, processors, you have to have an agreement. All of our processors have that agreement. When they get your information, when you've chosen to go with them, they'll send you their agreement. You just, they sign it, you sign it that you won't charge them a fee. They sign it that they won't charge them a fee. Basically, the worker cannot be charged a fee. It's a real problem, because people will pay easily thousands of dollars, I mean, depending on where they're coming from, to get a visa to come into the United States. Another reason you don't want fees being charged is because usually if somebody's paying a fee, they're paying a fee to get in the U.S. to go somewhere for a higher paying job, you know, and so they're just going to use that visa. So you don't want anybody paying a fee. You want just workers who are going to come up and work for you. You know, so yeah, the only thing that they can pay is their passport. They can pay for their passport. You don't have to pay their passport. Everything from then on, even the transportation going up to the consulate. Another thing a lot of people aren't paying is our processors have pretty inexpensive housing for when they come up and they're in Monterey, like $20 a night. The employer has to pay that, because from the place they've been recruited from, so the bus fare from their home to the consulate, the boarding house that they use there, that they charge them for, the employer has to reimburse that to the worker. So no fees to the worker. No preferential treatment to the foreign workers. A lot of times that's what's going on. The foreign workers are getting preferential treatment because they really like, employers like them coming up. No discrimination. The employer's got to do all the recruitment of U.S. workers and attempt to hire U.S. workers. All that's required in the recruitment is a good faith effort to hire the U.S. workers. And very few U.S. workers are even showing up for an interview. But if they do, and somebody shows up one of these applicants through the State Workforce Agency, and they show up and they say, I have always wanted, I actually ran into this for the first time this year. I ran into a guy, he actually came to our church, and he said, do you know where I can get a job? I said, yeah, I know a lot of places you can get a job. And I said, but most of them are landscaping work. Do you want to do that? He said, yes, I've always wanted to be a landscaper. I said, I've never heard anybody say that. We don't run into that very often. But anyway, so I hooked him up with one of our employers. Recruiting, continuing obligation, we're almost at our cutoff time. I'm going to finish these obligations and then we'll take a break. Continuing obligation to consider U.S. workers up to 21 days prior to the start. So when you submit a recruitment report, that's not the end of it. You've got to continue to interview U.S. workers and offer them the job if they're interested up to 21 days prior to the start date. So if you have an April 1st start date, you've got to continue interviewing any applicants up until March 11th. So up until 21 days prior to the start date, you have a continuing obligation to recruit U.S. workers. There can be no strike or lockout. I've actually had this happen a couple of times. Fortunately, we caught it in time. I had an employer tell me, yeah, once my H2B workers get here, I'm going to let all my U.S. workers go. You know, they're just not doing very good work. I said, no, you can't do that. You can let that happen by attrition, that when they quit, you know, but you can't lay them off when your H2B workers get here. No recent or future layoffs. That's that one. Contact with former U.S. employees. You do have to contact your workers that have been laid off, not ones that have been fired or quit, but ones that have been laid off in the last 12 months. You have to contact them and offer them employment under the new terms. Area of intended employment. The workers can only work in the area what they've been approved for. If they were to go to a different MSA or a different city, the wages could be higher there, and they're undercutting those wages by being in that higher paying area working. So they can only work in the area of intended employment they've been approved for. Abandonment or termination of employees have to be reported. So if a U.S. worker, a foreign worker takes off or quits or is fired, you have to report that to DOL. It's just an email. You just put it on an email, and we give you the email address later in the book. We'll show you that. Compliance with applicable law. You have to keep all the employment laws. Disclosure of foreign worker recruitment. There has to be a copy of any agreements with foreign processors, and they'll provide you with that. And then if there's an investigation, you have to promise to cooperate with investigators. But if you have an attorney, I will cooperate as well, but I will be a buffer between you and them. And we'll go into how to handle it if an investigator shows up here later this afternoon. All right. We're going to go ahead and take a quick break. And we have some coffee out there, and we should have... Lachelle, could you check and see if there's pastries out there? There are. So there's some pastries out there. Then we have a big hacienda lunch at noon. And then we got their famous chocolate chip cookies here in the afternoon. So let's go ahead and take a break. We'll start back up here in 15 minutes.